Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. In this video, we are going to discuss an important topic. The topic is, can police aid be given in civil cases? You all know, yes. But under which provision of law? Under which order? This you have to know. So even though there are 158 sections and 51 orders in the CPC, there is no specific mention as to how to get the police aid in civil matters. The JDR may be a powerful man. JDR may be keeping some rowdies as obstruction. Even though the EP says that you are the owner of the property and that you are given the possession of the property, he will not allow you to come inside. In such case, what to do? The only remedy is getting police aid. But where is, under which provision of law, you can do it. So please remember, definitely police aid can be given even though not directly. First of all, refer to section 94E. Section 94E, it clearly says such other orders. 94 I will tell you. 88, 94. The supplemental proceedings, they say like issuing a warrant for execution, issuing a warrant arrest, furnishing security, then giving a temporary injunction or appointing a receiver. And E, please remember, make such other interlocutory orders as may appear to the court to be just and convenient. Yes, under this section, they can give the police aid. Any interlocutory order. Likewise, I have always been advising you to add section 151 of the CPC. What for? It says about the inherent powers of the court. So nothing can limit the court in taking steps to make the ends of justice or to do complete justice or to prevent the abuse of process of law. Okay. Now, section 151 gives the enormous powers to the court. And lastly, we'll come to Rule 35, Order 21. Right. There is a decided case law because today I am going to tell you the so-called affidavit, caveat, and also the so-called police aid lastly. So therefore, I am making this video. Please refer to the case. This is Bijiga Paparao versus Jonnalagadda Srinivasa. They belong to Kedada. Of course, it is combined when it was combined Andhra Pradesh. Right. So, Bijiga Paparao versus Jonnalagadda Srinivasa in civil revision petition number 2919 by 2014. The decision came on 7/11/2014 by Honorable Justice Akula Venkata Sai. Presently, he is also working as a AP High Court judge. Right. So, if you go to the facts of the case in brief, it will be better for you to understand. This Jonnalagadda Srinivasa, he has instituted a civil suit in OS number 103 by 2012. So, seeking, please remember, title over the property and also permanent injunction. So, in relating to certain land located in survey number 1073 by A of Anantagiri village. So, this may be in Kodada area. I am sure it is near Kodada. Right, you all know that under section 26 CPC, read with 151 CPC, he might have instituted the civil suit. Then he filed an interlocutory petition because even the suit is for injunction order, but whatever it is, he filed an IA. So injunction is the interlocutory application for permanent injunction. So he has filed under Order 39, Rules 1 and 2. And he has requested the police aid also. The local junior civil judge, at the time he was called Musif, whatever it is, the junior civil judge granted the police aid. Agreed by this, the other party, that is Bijiga Paparao, he approached the Honorable High Court of Andhra Pradesh. Here, the important points, of course, High Court of Andhra Pradesh agreed with the conclusion of the lower court. The JCJ is 100% correct. But the wording is more important for you to understand. Therefore, I am reading. The AP High Court said, granting of police aid is an extreme step So the routine steps have to be followed, like sending the court emissary to the place, then the other fellow objecting, then this man coming to the court and reporting the matter. This all order 21 I told you. Then only the extreme step, the last step of resorting to police aid will be given. Please remember, so it cannot be made in a routine manner. It cannot be made unless the court is fully convinced or fully satisfied about the existence of the grave emergency, about the extraneous circumstances. So the circumstances should be that this DHR cannot enter the premises without the police aid. Please remember, however, please remember, the said power is to be exercised with due care and caution. So you can't, the judge cannot give the police aid in a routine manner. Right? So in this connection, even the JCC is also correct. How? Every court is endowed, every court is constituted for doing justice. There is no specific provision of law which is sufficient to implement the order of the so-called temporary injunction or decree for permanent injunction. Specific provision of law is not there. But we do not see why section 551 CPC can be invoked for that said purpose. That means for doing justice, yes, under section 150 of the CPC, yes, police aid can be given. Right? So therefore, in appropriate cases, in reasonable cases, directions under 151 CPC can be issued by the civil courts to the police authorities. For what? So to extend their aid and assistance in the execution of the decree portion. And actually, the court can order police aid under section 151 CPC. So please remember section 94 clause E and also 151 CPC, right? So JCJ is 100% correct. Therefore, the civil revision petition, revision is under section 115 is correct. So revision petition is dismissed. In this connection, there is another Supreme Court case law. So here they have mentioned Order 21, Rule 35. In that Rule 35, please remember, the court may, through its officers, so who are officers of the court? Lawyer, he is officer of the court, and police aid. Police officer means he is a public officer. Section 2, clause 17 of the CPC deals with the public officer. Yes, the public officer is expected to assist the court. Police officer is a public officer. So, as per Order 21, Rule 35 also, police aid can be given. So, this was decided in the case of Savita Gupta versus V. Sudhir Jaju and others. In CRP number 69/92 dated 3/10/1996 by I think Supreme Court Honorable Justice Shivakumar Sharma, Supreme Court judgment I believe. So like that police aid can be given, but there is no specific provision. So in order to make you learn how to get the police aid in specific cases, I have made this video. So it will be useful not only to the lawyers, not only to the law students, but general public also. So normally they will be under the impression that if you ask police aid, so they do not know. They think that they may have to go to the police station to get the police aid. Of course, as advocates, we can guide them properly. In this connection, as far as police officers concerned, please remember I have done one case. There is a company, tobacco company by name Malnadu Tobacco Company belonging to Karnataka. So they got a police aid order to shift their tobacco checks or tobacco bundles from Chinnakottapalli village to their godown in Travagunta. But it will not possible because just 1 month prior to that, there is a police firing in Tangutur village in which 3 persons died. Suppose if we give police aid, all the people are waiting outside because they did not get the money from these Malnadu Tobacco Company people. Therefore, definitely there will be resistance and we expected once again some fatalities. So, as a third party, on behalf of the police, we filed an intervention petition before the senior civil judge Ongole and requested him directions. So, Your Honor, we are ready to oblige to the orders or police said, but things may go wrong. If it goes wrong, some people may die. Then he said, no, wait for some time. He asked the Malnad company people to hold negotiations with the agriculturists or riots and then come up. Of course, the issue has been amicably solved. So these are the problems. So you can tackle in any way you like, so according to the circumstances. Very good. So please remember these case laws and enrich your legal knowledge. With this, I am concluding. Thank you very much.